Hello everyone, welcome back. In this video, I'm going to talk to you about the concept of being, quote, re-Baker acted. Now, I've talked to you about this in other videos, but this call that I just got was really unique, and it's sort of a different flavor, a different twist on the re-Baker Act concept. So here's the deal. I got a call from a gentleman. His wife had been taken to the emergency room for an alleged overdose. She was Baker acted there. She was taken to a facility, a receiving facility, and they gave her a medication which caused her to have a medical complication to the point where she had to be rushed to the emergency room. So she was at least 48 hours into the 72-hour hold on the Baker Act. They took her to the hospital because she was having a medical issue. She was detained there overnight, and while she was there, she was told she's being re-Baker acted. She was sent back to the receiving facility, and they said, oh, you've been re-Baker acted, so the 72-hour clock starts all over again. And I said to the husband, no, it doesn't. But because there's no oversight with the Baker Act, because nobody knows she's there, they don't care. And you're being lied to. So here's how this works, okay? If somebody's involuntary, that means they can legally be held up to 72 hours. After 72 hours, one of three things must happen. And that's presuming that the facility actually follows the law. Number one, they're released. Number two, they get your loved one somehow to sign a voluntary admission agreement. Or number three, they file a petition for placement, asking a judge to order an extended detention, potentially up to 6 months. Now, at the beginning of this whole scenario, she had been taken to the emergency room. The statute says, and actually the 2024 version of this really clarifies things, says that even though she's Baker acted at the hospital, the doctor has to document in her file that the medical emergency is now over. Now, under the 23 version, our argument used to be that once the medical emergency is over, now the 72-hour clock starts to tick. The 24 version of the Baker Act statute says, no, the clock doesn't actually start to tick until she arrives at the Baker Act receiving facility, whether that facility happens to be inside the hospital, because some hospitals have their own Baker Act facility, or at another facility where they've transported her to. So it really clarifies things. So arguably, when this lady got to the receiving facility, the 72-hour clock started to tick. When she had a medical emergency and she was taken to the ER, the 72-hour clock stopped. In other words, it was told. It didn't start all over again. It just stopped, okay? And that's my interpretation of the statute. I think that is correct, okay? The 72-hour clock stopped. Remember, there's a medical emergency. At the beginning of the case, the medical emergency didn't begin the clock to tick, and here it stops it. So what the hospital did when she went there for the medical emergency, this is the second trip to the ER, remember, is they said, no, we're starting it all over again. That was wrong. It was illegal, and it was just an excuse to keep her. You know why? Surprise, surprise, she's got unbelievably good health insurance. And so when they took her back and the receiving facility said, oh, you've been re-Baker acted, they started the 72-hour clock all over again. Completely illegal, complete BS, and it was wrong. Remember, at the end of 72 hours, they either release you, get you to sign a voluntary consent, or they file to keep you by filing a petition for placement. They didn't do any of those things, and they cannot restart the 72-hour clock. You don't get a second bite at the apple. It doesn't work that way. It's 72 hours and done. So if she spent 72 hours in the receiving facility, they should have exercised one of those three things. They didn't do it. You can't just re-Baker act somebody. But again, nobody knows you're there. Nobody's watching. You can't sue them for this stuff, so they don't care. They simply don't care. And so I said to the husband, look, you got to fight to get her out, because all the indications are that they're planning to keep her. They keep moving the goalposts. They keep telling her, you're getting out today. You're getting out today. You're getting out today. This has been going on for days now. And I said to him, you got to fight to get her out. All the things that you're telling me suggest they are planning to keep her, and they may well have already filed that petition for placement. But because it's done in a confidential manner, there's no way for me to know this. And so if you don't take action, you're running the very serious risk that sometime next week, she's going to end up in a placement hearing. And even if they have already filed, at least if we file something, there's a possibility the hospital will capitulate because they won't want to deal with me. And at least they know what's going to be coming down the pipe when they file this ridiculous petition for placement, if that's what they've done. But this was a new twist on the, quote, Re-Baker Act. I wanted to share it with you, and this is just another example of why the Baker Act is really messed up here in Florida. And unfortunately, our legislators missed a very, very big opportunity to fix this thing. Should have called me. I would have told you what to do. Anyway, I want to share that with you. I appreciate you tuning in, and I will see you in the next video. Bye-bye.